Welcome to My Court Coach. Thanks for being here. Hey, we have Chris here once again. How are you doing, Mr. Funtal?
Good. How you doing, Tate?
I'm doing good. Thanks for joining us. So if you're watching this live stream, I want to welcome you and remind you that my name's Tate Lounsbury, and I'm with MyCourtCoach.com. This is Chris Funtal, family lawyer extraordinaire in California, and we're here to see if we can answer some viewers' questions. As we're doing that, though, keep in mind that we are not providing legal advice. Chris is not providing legal advice. We're not your lawyers. And everything you see here is entertainment. And so we're not establishing an attorney-client relationship. If you decide to ask us a question in the comments, we welcome that. Encourage you to do that. We will be happy to, or Chris would be happy to offer any kind of information that he can provide, any of his thoughts that he can provide. And then you can come back and watch that anytime you want. But if you do leave comments, we encourage you to not provide information that's personal, that's of a personal nature, such as people's names, especially kids' names and things like that. And of course, to not ever denigrate anybody or be insulting to an ex-spouse or anything like that. Okay. Should we get started? I think what I'll do is I'll go ahead and share the first question that we have here from a viewer. Let me pull it up. All right, can you see it? This is a question that relates to the DV-120 form, responses to requests for domestic violence restraining order. And the question is related to the number 4, the fourth item on the form. Number 4, relationship to person. My last roommate served me with the DV-120. We were never in a relationship, but we fooled around, nothing exclusive. Or I think it means or intimate. So this is referring to the domestic violence restraining order. And what do you have to say about that?
I'm not sure what he's asking. It sounds like he's suggesting that they weren't in a boyfriend-girlfriend relationship, but they were. I'm not sure what fooling around means. It says, but we fooled around, nothing exclusive or intimate. So I'm not sure if that would be a boyfriend-girlfriend relationship or not. The best way to fill out number 4 is to say pretty much what he said there. We were not in this kind of a relationship, and to be up to the judge to decide whether or not that is enough of a relationship to fall under the DV statutes. Obviously, he should fill out the rest of it as well. We have no idea from the question what else is going on in that case. So I can't really tell him how to fill that out otherwise.
Yeah, those are the family code has, I'm not remembering exactly which family code it is offhand, but the family code has the statute lists the different relationships that qualify as a relationship for purposes of the domestic violence. I think it's called the Domestic Violence Protection Act or the Domestic Violence Restraining Order laws. And it's hard to say. We can't say for sure that, no, you didn't qualify, because that's up to a judge to decide in your specific case. And we don't know the details of your case. But that's a fabulous question. Typically it refers to people who are dating. Any more comments about that?
No, I just think it's kind of a tough situation, I guess, because it's not real clear whether or not a court would find that they were in a dating relationship or not.
Yeah. The code sections that you're going to want to be looking for, if you look at we have a video in our, I'll share the video with you here in a minute, that goes over how to find the statutes, and it's going to be Family Code section 6300, 6300, and or 62 around 6200 and around there, where it talks about the domestic violence laws. And so take a look at 6209. I think that's where it talks about cohabitation, and a dating relationship is Family Code 6210. And it says a dating relationship, this is, I don't know if this is current, but what it used to say, at least, and I think it still does, dating relationship means frequent intimate associations primarily characterized by the expectation of affection. And so the judge will look at, what does that mean, fooling around? Judge might look at, is there a financial dependency there? Are you guys really roommates, or is there any kind of situation where you're taking care of the other person, or the other person's taking care of you financially? But great advice. You can just say no. That's one thing you could do. Or great input is you could just say no, and then let the other person try to prove to the judge that it was a dating relationship. Anything more on that?
Nope. Sounds good.
Yeah. Okay. Let's look at the next one. Okay. This is about a question on our video, all you need to know about wage garnishments and income withholding for support in California. And this person asks, what can I do if a judge issued a new order on a garnishment of $50 a pay period, but the plaintiff is refusing to send out an updated order to all parties as required by the judge in the minute order? So the commenter wants an update to this garnishment order. Maybe it was higher before, and this commenter wants it to be, and it's now reduced down to $50 a pay period, and the other person doesn't want to give notice of that because it doesn't, it hurts them.
Yeah, I'm guessing the original order was higher. In that case, the person who is wanting the order to be submitted to his employer should prepare the new wage garnishment, get it to the judge, get the signature on it, and then that person can send it to their employer to show that it's the new lower amount. If for some reason it's a higher amount than previously ordered, then the person shouldn't do anything. Let whatever the lower amount be taken out of his paycheck, and then to the extent that there's a shortfall, they can send that in directly, and it doesn't say whether this is child support or spousal support, but if it's to child support, you send it to the state disbursement unit, and that way you get credit for it. Whether or not there's an actual wage garnishment in place doesn't limit this person's obligation to actually pay the full amount every month. But they can wait and see how much their employer actually takes out of the check before they do anything.
The commenter can wait and see?
Yeah, I mean, if you don't know whether or not the judge is, or if the employer is going to take the full amount out of your paycheck, wait until you see the paycheck to see if it's taken out.
Mm-hmm. And then if it's not, file a motion or a contempt, or?
No, just send because this person is the payor. So then they just send the money off to the state disbursement unit, and they get credit for having paid it that way. And as a side note, anybody who's paying by wage garnishment should send it directly to the state disbursement unit, and they should sign up for an account with them, which takes a few weeks to get set up. But once you have an account with them, you can log in and make sure that you're getting credit for all the payments you're making. It also makes it real easy to print out a list of all the payments you've made going back for years, assuming you've sent it to the state disbursement unit. You should avoid paying payments directly to the other side, because when you send it directly to the other side, they may come back and say, no, that person didn't pay me. And then you've got to, go to the trouble of getting a bunch of canceled checks to show that you actually did pay it. Obviously, you should never pay the other person cash unless you get a receipt. But even then, that's a problem, because what happens if you lose the receipt? So the orders, the current way that the state of California does it is they order you to make the payments to the state disbursement unit, and that's what you should be doing.
Very good. Thank you. I'm going to go back and just share this information on that other issue. Share this code section for the last question. So if you take a look at, if you just do a Google search for family code 6209, you'll find a page like this, the California Legislative Information. And you scroll down to family code 6209, where it talks about a dating relationship. Okay, thanks, Chris. Let's say we go to the next question. We actually have a comment from a viewer here during the live stream right here. What are defenses against a motion to joinder from a grandparent when both parents are active and both have joint legal and physical? Sounds like this is, let's say this is a parent. Let's say it's a mom and a grandparent, whether it's the mom's mom, let's say, or the dad's mom. A grandparent's coming in and saying, "Hey, I want to get involved. I want some rights to custody of my grandchildren." So what are some defenses against a motion for joinder? Let's see what I think we have videos about this, actually.
Assuming both parents are actively involved and the court finds that they are involved, and not a situation where one of them is somewhat involved but perhaps missing because of drugs or something like that, then yeah, I would fight that. And the case that's on point for that is, off the top of my head, it's like Troxel, Troxel, and it's actually a federal case, which is kind of strange. We don't get too many of those affecting family court cases, but it's a federal case saying that people have constitutional rights to the care and custody of their children, and they should be able to do so without interference from grandparents and other outsiders, as long as both parents are in the picture. And so family court judges know this, and so that's a good argument to keep grandma and grandpa out of the picture.
Hi, thanks for using My Court Coach. I'm Kimberlina, and I'll be your instructor as we talk about.
Is that you?
Sorry about that.
But yeah, I assuming both parents are alive and doing well, I would fight to keep meddling grandparents out of the picture. Mm-hmm. Because now all of a sudden, you have a situation where you got to do visitation 3 ways. I mean, it's difficult enough getting 2 parents to figure out how to do visitation sometime, and throwing a bunch of extra grandparents, aunts, uncles, and the neighbor in there isn't going to make it easier.
Yeah, and I know we have videos here on YouTube about that. And if you go to our playlists and the channel here from My Court Coach, look through those playlists, and you'll see videos about joinder, and that question will be discussed, and that'll provide you with more information. Again, look for that joinder. Okay, if that didn't help, if there's a follow-up question, go ahead and ask it. Okay, let's look at the next one. All right, this is a question or a comment on our video about the ex-parte application regarding support payments coming straight from paycheck by employer. And this commenter says, what if you're unable to submit proof because you do not have copies of the diploma or birth certificate, etc.? That confused me a little bit. I don't know if you have a better idea of what that's talking about than I do.
Well, in order to terminate support, you have to show the court that the child is 18 and out of high school, or 19 at the latest. And assuming you can show that, then the court will do it on an ex parte basis, probably. different courts will do it differently, but usually that's a drop type thing, and you don't actually talk to the judge about it. They take a look at your paperwork, and then they will issue the order. As far as not having the birth certificate, that's usually not fatal, because usually the orders have the child's birth dates on them.
Mm.
And so if the judge can look back at the judgment or whenever they made the last order for child support, it usually says, baby name, date of birth, and it has the date of birth listed. So if that's the case, then the judge can proceed without having the birth certificate. And in fact, I would avoid filing birth certificates in family law cases, because that's public record. And putting your baby's birth certificate out there, or your 18-year-old, as the case may be, it's out there forever. And so I would be very careful about submitting birth certificates attached to a declaration that's in a public file. Same thing with social security numbers and tax returns and stuff like that. Now, the other part of this question is, what do you do if you don't have proof that the child has actually graduated? That's going to be a problem. Why would the court take your word that they're graduating if you don't have some smidgen of proof? In which case, what the judge would probably do is set the matter for hearing to give the other side an opportunity to contest whether or not the child has in fact graduated from high school, if that's a requirement. Like if they're 18 and out of high school, and you're using the out of high school portion to terminate the support,
Mm-hmm.
And you don't have proof that they're graduated, well, then the court's going to have a hearing, and it's going to look at the other side, and is this person really graduated? And if they say no, but it turns out that they are, obviously you're going to be able to prove that eventually. But I don't know of a good reason why a parent can't contact the school to get a copy of something showing that their child has graduated from high school. I mean, it's one thing to not have a birth certificate, or, you haven't seen it for 10 years, or, something like that. But, when the child just graduated last week, usually that information is available.
Yeah. If all else fails, you can send a subpoena. We have videos on subpoenas to the school, perhaps.
As long as a parent has joint legal custody, I can't think of a reason why the school just wouldn't voluntarily provide that. I mean, they may require that you physically go down there and do it. And if you live out of town, they may have to come up with some other way to do it. But I mean, principals generally don't want to be difficult for the sake of being difficult, because they're going to get a lot of screaming parents in their face if they do that.
Maybe there is no legal custody. Maybe the payor doesn't have legal custody.
Yeah, maybe. But then you file a motion and you send in a subpoena, like you said. Obviously, that's going to take more work.
Yeah. If you have an email from the other parent about a graduation, that would be a whole lot easier. Like, save the date, or, a lot of times when someone graduates, a kid graduates, they send out these announcements, letting people know, hey, I graduated. And yeah. Okay. Let's go back to the other issue that we had. This commenter has a follow-up question, and let me just show this questioner here, something that you can do when you're looking at our channel. So I think you can see this is our channel, and here you'll see this little search bar right here, or a magnifying glass, and if you just put joinder right there, you'll find our videos that discuss joinder. So how to respond, here's one video, how to respond to a motion for joinder in California Family Court. That might be a video that you're going to want to watch to see if that can answer some of your questions. Another video that you're probably going to want to watch is in our playlists that talk about the basics of family law. We have videos that explain, when you see a form, how to find the statute that addresses the legal issue that you're concerned about. And so if you turn to the log, look at the statutes, that's usually going to be your best bet in finding an answer. That's what we do, is we go back and look at what do the statutes say, and what does the case law say. We also have videos that talk about how to search for case law. But the question is, why do judges allow joinders since it's a constitutional right? Parental rights. Why does there need to be an evidentiary hearing when it seems unnecessary when both parents don't agree for joinder? In other words, when both parents say, we don't want grandparents involved. Any comment on that?
You didn't quite read the question exactly as it's written, but it doesn't necessarily make sense. Joinders are not a constitutional right. Parents have a right to parent, and parenting is a constitutional right. So why do judges allow joinders? Well, they got to deal with it on a case-by-case basis, and the court has to decide if it's appropriate in a particular case to allow a joinder or to disallow the joinder. And, in some cases, you'll have a parent that has passed away, and it's in the child's best interest to have some continuing contact with the dead parent's family. So in that case, the court probably would allow some kind of a joinder and some kind of a visitation. Exactly what that would look like is not real clear to me, but it just depends on the circumstances. And then they would send the parties to talk to the social worker at Family Court Services or whatever they have in the county you're in to decide how to address visitation. Obviously, it's going to be different if the grandparents live in the same city as opposed to all the way across the country. But then it says, the next part of the question is, why does there need to be an evidentiary hearing when it seems unnecessary when both parents don't agree for joinder? Well, an evidentiary hearing is a way for the judge to give everybody an opportunity to present evidence. And I'm not sure who's presenting the evidence, but it sounds like one parent says the joinder is good and the other says the joinder is bad. I don't think that's really going to win or lose the day. The question is whether or not one of the parents disagrees with it, and whether or not the court can allow the grandparents to intrude on their rights. And it sounds a lot more complicated than we can put in a little text message box over on the side here, but it's a complicated area of law because we don't see it very often.
Mm-hmm.
There really aren't that many grandparent joinder cases.
Yeah, the courts want to look. They want to protect the children. They want to do what's in the best interest of the children, and so even though obviously parents have constitutional rights, children, as just people, have constitutional rights, and so you get this conflict. You get these competing rights, and I think that's why courts allow for evidentiary hearings on joinders.
Yeah, and I'm not sure why the court would have an evidentiary hearing as opposed to a regular non-evidentiary hearing. But that's just one way a court can do it, and it sounds like that's the way the court in this particular case is doing it. The court doesn't like to have evidentiary hearings if they don't think it's necessary because it takes a lot of time. So I'm sure the court wouldn't have said it if they didn't think it was necessary.
Mm-hmm. Yeah. And so it's hard to get into the details, and we don't really want to get into the details here and on this live stream as to why a specific judge makes a specific decision in your case. Who knows what's going on, whether there's drugs on part of both parents or, who knows. But you'll have a chance, of course, to present your case, and the grandparents will have a chance, and hopefully it all turns out for the better. We have another question here about what is the legal definition of a person to a court? I'm not sure if this is in response to or something that's related to family court or something else. Can you tell us, are we considered a person in court? Yeah, Yeah, if you do a Google search for California Family Code person definition, you'll find responses to that. You'll find your answer. I'm not sure if this is talking about children. Yeah, in family court, this person says. There is actually a code section. I'm not remembering what it is offhand. There is a code section that actually talks about what is a person, and it's really focusing on a child. What is a child? And it gives the parameters of the first, the end is, of course, when you turn 18, and when is the beginning? And I'll have to see if I can find it while we're talking, but there is a code section that says when a child is actually a child for purposes of custody and things of that nature. Do you happen to know what it is offhand?
I don't even know what this person's asking about.
Yeah, it's hard to say if they're talking about themselves as a litigant, as a party to a case. Am I a person? Which, if you're a person, then you are a person. Or if they're talking about a child, a person of the United States. Is this about citizenship? It's hard to say what this is, or is it about a corporation? You can take a look at Family Code 105. Maybe that will help you. Family Code 105. Go ahead and put that in Google.
So there's another add-on comment that a corporation is a person. Well, yeah, that's kind of true in some context. I've never seen a corporation try and get custody of a child in family court, so I just don't understand how that would apply to family court.
Yeah, me neither. Never seen it. Maybe this person has a unique situation. Gotcha. Let's take a look at the next question here. Another comment. Okay, this is a comment on the last live stream we did last week. And this is really about tenant law, landlord-tenant law, it seems. I was never served or told about a trial date. I just found out about this eviction 2 weeks ago. Now they say I have a week to get out. I know nothing at all about landlord-tenant law, like zero. And it's not really an issue that we address at all in My Court Coach and any of our videos or any of our resources on our website. And so this person is essentially hoping they don't get kicked out and become homeless. Do you have any? Do you know?
The answer to that one is get down to the courthouse immediately and go to the tenant legal help group there, and then they will help you fill out paperwork so you can file a motion saying that you weren't served. The judge, if they believe you, and I don't see why they wouldn't, will put a stay to the matter and have a hearing and take a look and see what's going on, because evicting people without giving them proper notice is a very bad thing. And that's the court's opinion on it. So they want to make sure people have notice and they get a chance to have a hearing on whether or not they've paid rent or whatever the reason is that the landlord is trying to evict them.
Yeah, and I don't know where this person is located, but if they're in an urban environment where there's a law school nearby, the law schools often will have law students who will provide help in these unlawful detainer situations. There are often nonprofit organizations that have lawyers who you can talk to for free if you're a tenant to fight unlawful evictions. So there will be resources if this person looks. They'll find resources to help them. And as you said. Well, that's all the comments that we have on our videos this last week. Really appreciate the comments here on our live stream. This last person said regarding the person. Yeah, it's strange they don't say a man or a woman. That's all we have. So for you who are viewing, we recommend if you have questions to go ahead and comment on the videos that you are watching. We do hope those videos are helpful. We hope our input here today is helpful. I want to remind you that we are not providing you with legal advice. We're not giving any suggestions on any kind of legal strategy or what you should do in your case. These are some things for you to consider and think about, but not legal advice. Chris Fontal, thank you so much for helping us. If you want to learn more about Chris, you can do a Google search with his name. And any last comments, Chris?
No.
Okay. All right. Thanks, everyone. Please go ahead and like and subscribe. That way you'll be notified next time we do a live stream. And if you appreciate this and appreciate two lawyers just trying to give back to the community, we sure appreciate a like and telling your friends. If you have a friend who's going through a custody issue who needs some help, go ahead and say, hey.
I'm reading these comments from this guy that had the question about the person. And I quickly looked up the section he's talking about. So it has something, his question has something to do with service on somebody out of the country. And it's a real complicated area of law because you're dealing with federal laws. And so under the federal statutes, they might refer to somebody as a person. That doesn't necessarily mean what they're going to do with the state laws. And every state has different words that they use in the various family courts. And in fact, some cases, some states don't call it family court. They'll call it juvenile court. Whereas here in California, juvenile court has a much different meaning. Like in California, family court refers to divorces and paternities, whereas juvenile courts are dealing with juvenile dependencies and juvenile delinquency issues. And so, yeah, I'm not quite sure what he's doing. You know, these international service issues are very complicated. I've had a couple of them over the years, but only a couple. And it's always different depending on which country you're trying to serve people in. So I would suggest that you find somebody that really knows what they're doing when they're doing that, because, I mean, just serving somebody in Tijuana just across the border, it's not very far away, but there's a process you got to go through to get something called the notary from the state to serve that on your behalf. You can't just serve it on somebody at their work in Tijuana. Real complicated stuff.
Yeah, we have a couple of videos here on YouTube about international family law issues. They are incredibly complicated. I only know one lawyer in San Diego who really knows his stuff, and he was a former attorney general, deputy attorney general, and because they deal with kidnapping and all that kind of stuff. So we hope this is helpful. Go ahead and give a like if you think this is if you appreciate this. Thank you so much, Chris, and we are signing off.